Hi there and welcome to the Employment Law Show once again. John Scholes, Lior Samfiru joining you again this week. I want to reach out ahead of time. I'll tell you how to do that before we get into the meat of the show for this week. The phone number anytime is 1-855-821-5900, help@employmentlawyer.ca, and the website, which will get many mentions over the next 30 minutes, pocketemploymentlawyer.ca as well. We'll give you that throughout the show, so don't worry if you missed any of those contact information details. On the show, 5 key questions about constructive dismissal on the way in just a bit. That's going to be the main topic for the show. But as we always get warmed up, Lior, that would be the week that was. That's how we start this off. What's going on, pal?
Hey, John, great to be here. Great to talk employment law and to hopefully help as many people as possible with respect to workplace rights. This is the place where you learn about those rights that are so important to you, those rights that impact you, because we all have jobs and we all spend so much time in our jobs. So if you're wondering about what to do, if you're facing a workplace problem, if things are not going well, if your boss did something, said something, suggested that certain things are going to happen, what to do, how to respond. We cover those things, of course. You'll learn those things by watching the show, but you can do something beyond just the show. You can always reach me in the office to talk about your specific situation, your specific problem. We'll give you that contact information throughout the show. I want to have that discussion with you. I want to make sure that you feel that your rights are there and protected. But to start us off with respect to something that came across my desk recently, I spoke with a lady who, at the age of 65, made the decision on her own that she plans on retiring. She wanted to be very fair to her employer, so she told them that she's going to be retiring at the end of the year. She told them, yeah, in a few months, at the end of the year, this is going to be my last year. I'm going to bid farewell and retire. Her employer said, okay, that's fine. And they brought someone in for her to train. Okay, so far no problem. And then a few weeks later, when this person was trained, the employer said, well, we actually don't need you to stay till the end of the year. We have the ability, they said, to waive your notice. We're going to say goodbye. You're just going to retire now instead of a few months at the end of the year. So she was upset by that because obviously she planned on continuing to work. You know, she wanted to and needed to continue earning income for a few more months. So she called me and she wanted to know, can they do this? I was going to leave in a few months. They want me gone today. What does this mean? So what this means is, yeah, you can't stop them from letting you go now, but they still have to pay you until the end of the period that you gave them notice for. So if she gave them notice for another, say, 3 months, they have to pay her for those 3 months. In most cases, if in fact you provide notice and your employer lets you go before that notice, well, they have to give you pay, to pay you until the end of that period of time. In some cases, not going to get too technical here, it could even be beyond that period of time. So employers have to understand that. It's not as simple as just waiving that notice. You're going to leave anyway, now you're gone today. You want them gone today, you have to pay. You can avoid that, and that could be, like with this lady, significant amounts of money owing. So remember that. Of course, always try to be fair to your employer. If you're going to resign, if you're going to retire, give notice. But you have rights if that notice is, so to speak, waived.
Would that whole thing have changed if she'd said, you know, eventually, guys, I'm going to leave? Man, I'm thinking about it. I'm kind of tossing around the idea in my head. Eventually, I'll leave, but for now, I'm going to stay. And then they said, well, that's okay. We got your replacement. Out you go. Would that be different? You
know, actually, that happens quite often. I see that often. Well, I'm thinking about retiring. I'm thinking that this may be something I want to do. Well, let's just end this today. That's fine, except that employer would have to pay severance, and full severance. So even though that employee may have decided to retire in a couple of months, if the employer terminates on their own, severance would have to pay, which could be 2 years' pay. The other thing, of course, if the decision to let the person go is tied to their age, well, that could be age discrimination and a human rights violation. So I certainly would advise employers against that.
And does it change if it was the employer who said, you know, 3 months from now, you're going to retire, we're letting you go? They gave her notice, and then they reneged on the notice? They'd still have to pay, right?
That's right. Okay. So, yeah, if an employer reneges on that notice, you can't really put that horse back in the barn. And yeah, you'd have to pay. But keep in mind, an employer cannot require an employee to retire. So if an employer says, well, you know, you're older now, so we just decided you're going to retire, you're 65, you're 66, whatever it is. No, there's no such thing as mandatory retirement. You can't tell or force an employee to retire ever.
Many reasons to go to the website employmentlawyer.ca at your own time. There's also the reason to find one of the radio shows across the country and here in the GTA that carries our radio show for 11 years we're looking at now. We get a lot of great calls on the show. We really appreciate you tuning in every week, making those phone calls, asking your questions. We like to play them back here and talk about them, Lior. So the first phone call from our radio show is coming up right now.
I worked for a company for 5 years. I'm 68 years old. I was just a delivery driver. I got laid off when COVID hit, called back. I was there for 9 months. I got let go. It's because the delivery truck had to go in for service, and the back door was all bashed in. They let me go because they thought I did it. I didn't do it. I got 4 weeks severance, and I didn't sign anything.
They're probably basing that on the 9 months where he came back. It sounds like it anyway, maybe.
Yeah, they might be, but I want to even address the fact that this accident that he had there with the truck, at the end of the day, it's an accident. So you can't really be fired for cause. They can't avoid paying you the severance that you owed just because something happened, and even if the company lost money as a result of it, and because you didn't do anything on purpose. Now, listen, if you're the type of driver, using this as an example, that always gets into accidents, they've warned you, you have to be more careful, and you don't, and yes, this is a pattern, then maybe there could be consequences, including maybe letting you go without severance. But in most cases, an accident, even if it costs the company money, it's the cost of doing business. That doesn't mean you can be let go for cause. Now, for this person, his entire seniority is going to count. So he's been there for a period of time. Let's see what severance is for him. We're going to use our severance calculator tool. You can find that, of course, at pocketemploymentlawyer.ca. Let's see what he actually gets. So we know that this person is a delivery driver, had been there for 5 years, 68 years old. Company says, oh, we're only going to give you 4 weeks, maybe because they think he did something with the truck. You can see he's owed as much as 8 months of severance, 8 months, even though he may have caused an accident that cost the company money. So, John, that's how easy it is to find out how much you're owed, pocketemploymentlawyer.ca.
His age factored in there for sure, because that's over a month per year, almost 6 weeks per year. That's a decent severance package, as it should be.
As it should be. The law presumes, right or wrong, that it may take longer to a 68-year-old individual to find a job than if he was 38 years old, and I think that's a fair assessment, and that's why age is one of the 3 big factors that impact the amount of severance that you get.
Let's get to phone call number 2. Let's see what that sounds like.
I work as a bill collector in a third-party bill collection environment, so I'm calling people and getting them to pay their bills. We're expected to collect a certain amount of money every month, and if you don't come close to collecting that number by the end of the month, you're expected to work for free on an additional Saturday. There might be 100 collectors in the office, maybe 10% hit their number, but the number is unachievable anyway.
That's a rough gig.
Well, I don't know if I want to help a bill collector, John. I don't know if I want to answer this question. No, I'm kidding, of course. But this is actually a very important thing to understand, because your employer may sometimes give you these targets, these ultimatums that are impossible to meet. So what do you do? And then you get penalized for not meeting them. So the first thing you do is, if your employer gives you these targets that are not attainable, is you have to say so. And of course, you have to say so in writing. You have to tell your employer, here's why those targets are not attainable. I'm, of course, going to work hard. I'm going to do my best. I'm a good employee. But I can't, I don't think, meet these targets, and here's why. You don't want that to be held against you. So if you're just silent and you continue working, hey, we told you to do this, you didn't do it. But if you tell your employer that it's not attainable, it's going to be extremely difficult to be let go for cause because you didn't meet those targets. The other thing is, there's no such thing as working for free. Let's be very clear. No such thing. Illegal. Doesn't matter who you are, what kind of job that you do. So if your employer says that you didn't meet your target, so we need you to work for free on the weekend, nonsense. By the way, they can't even make you work on the weekend. That could be a constructive dismissal. So there's all kinds of wrong happening here. Best advice is, if your company does anything to you, just give me a call.
What should the employer, how should they have handled this from the start?
Well, the employer should have set reasonable targets, and if the employee cannot meet them, try to figure out why. Can we provide better training, better support? Is there another reason? If they're not meeting targets that they should be meeting, then you discipline. You provide a warning, you provide a second warning, and maybe then you can consider a termination. But you can't penalize them by making them work for free. You can't change their hours, and setting unattainable targets, frankly, is a waste of time.
We have another phone call to go, but we'll do that on the other side of the break, so stick around for that one. In the meantime, always reach out to Lior and the team on your own time, 1-855-821-5900, help at employmentlawyer.ca. We'll continue. It's the Employment Law Show. Stick around. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the Employment Lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do. They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. John Scholes and Lior Samfiru. We mentioned the phone calls. We get plenty every week on our radio shows. You'll want to find a station near you where you can tune in and call in as well. Simply go to employmentlawyer.ca. As I mentioned, phone call number 3, Lior, is coming up right now.
I was let go from my position. I was on modified duties recommended by a doctor that were agreed to by the company. I wonder if I have a case for discrimination. I believe that I was terminated because there were parts of the job I could not do while I was on modified duties.
What do you think?
So, John, this duty to accommodate, we've talked about this before, one of the most important obligations that an employer has. An employer has to accommodate an employee's medical conditions, their disabilities, and they have to do that as long as there's a doctor that supports the employee. That may mean reduced hours. That may mean providing assistance to do the job, finding a different job, the ability to work from home. There's many things that an employer has to do within this rubric of modified duties, and they have to do it even if it's difficult. It's not always going to be easy, and sometimes it can even be costly. And even in those situations, the duty to accommodate applies, and an employer has to make it happen. Now, of course, there are going to be situations where it's so difficult and so expensive to accommodate that the employer may not have to go that far. Unfortunately, and I've seen this time and time again, some employers just don't try hard enough, or they say, you know what, it's really too hard, we're not going to go there. And that's a human rights violation. Now, in this particular situation, if this employer had accommodated before, clearly they can do it. So they can't just decide, well, now we've decided we just don't want to. Now it's just too much, even though we've been doing it before. So right there, we may have a human rights violation. And certainly, you can never be let go because you need assistance. You can never be let go because you have a disability, you have a medical condition that the employer has to help you with. Even if it's impossible to accommodate you, it doesn't mean you can be let go. All it means is you may have to stay off on a leave until either your limitations change or the company's ability to accommodate changes. You cannot and should not ever be let go because of your disability.
And again, this is something that the employer always handled completely different than they did. Does it matter as far as accommodation? Was it a tiny little employer or a big employer? As a practical matter, a large employer may have more options, more resources, more roles they can provide an employee, so they may be expected to do more. A tiny little employer, let's say a corner grocery store with 2 employees, may not have many options, so we'll consider that. But that duty to accommodate still requires the employer to do everything that they can, everything within their power to accommodate. All right, key, or at least main topic for the show anyways, is 5 key questions about constructive dismissal. There's that term again. You're going to hear it again, and we're going to break it down. I mean, the obvious question off the top, Lior, just what is a constructive dismissal? What does it mean? How does it work? So a regular dismissal, of course, is a situation you're called into a meeting, you're being told today's your last day, we're going to let you go. That's a dismissal. Constructive dismissal is different. Constructive dismissal is not initiated by the company. The company doesn't let you go. Constructive dismissal happens when your employer does something to you that makes it difficult to continue working. Because it's difficult to continue working, because it's not what you signed up for, because it's a breach of the terms of employment, you now have the option potentially to consider that to be a termination and require the company to pay you severance. So the company may say, no, we're not letting you go. We're just implementing a new rule. You may say, no, by doing that, this is not what I agreed to, this is not what my employment agreement says. I am deciding that by doing that, you've terminated my employment. We call that constructive dismissal. Now you have to pay me severance. What are some common examples? So usually whenever we're talking about constructive dismissal, one of the most common examples is any changes to the terms of employment, like change to pay, reduction in pay. That's a big one.
change to hours, a demotion. Demotion can be embarrassing. It's not something an employer can do. A relocation where you've moved far away from where you were working before, that could be a constructive dismissal. Another example may be workplace harassment. Your employer does something, it allows you to be harassed, or it doesn't protect you or harasses you themselves, and now you can't continue working. That could be a constructive dismissal. Maybe your employer is asking you to do something illegal that, again, makes it difficult to continue working. All those things that make it difficult to continue working, which is not something that you signed up for, are examples and things that can lead to a constructive dismissal.
So if I'm working for somewhere and one of these changes has taken place, maybe it's a change of hours, maybe they've moved the shop down the street, relocated, and I keep working there, what happens?
Well, a lot of people are uncomfortable challenging their employer, right? And, well, yes, my employer reduced my hours significantly, but, you know, I don't feel comfortable doing something about that. I'll just continue working. The problem with that is once you continue working, you're going to be considered to have accepted it. And there's two big problems with that. Once you've accepted whatever it is that your employer did, then you're stuck. You can't change it. You can't go back and say, you know, I realized that 3 months ago when I accepted that hours reduction, that was a bad move on my part. You're stuck. But it gets worse than that. By accepting that change, let's say, again, an hours reduction, you've now given the company the right to do it again. So it's not necessarily going to be a one thing. Even though your employer did not have a right to do that to begin with, by accepting it, by continuing to work, you've given them the right to do it again. That's a huge problem. It could mean that if your hours are reduced now by 3 hours, well, because you accepted it, next month it could be another 3, and then 10, and then 15, and before you know it, you're working an hour a week. So I think you get the idea. It's a very bad idea, I think, to just accept a change, to continue working, and to ignore the problem.
So this has happened to you, one of several ways you could be constructively dismissed. How does the severance answer fit into this?
So if you're able to establish a constructive dismissal, if you're able to establish that your employer did something that they were not allowed to do, they reduced your pay, they changed your hours, they were not dealing properly with harassment, then the law considers that to be a termination. And the same rules with respect to severance that apply in termination apply here as well. So you're going to be owed severance based on your age, your position, and the length of your employment, and that could be as much as 24 months' pay. So the amount of severance that you get with a regular termination, it's the same as the severance you would get with a constructive dismissal.
So a big change has taken place. It's a constructive dismissal after you know that after watching this show. Do I just say, all right, forget it, I quit, I'm out, and then go back and try to get severance after, or how do we manage this one?
Not the best approach to just leave. First of all, it's not every change that results in a constructive dismissal, so you don't want to quit and then realize, wait a second, it actually wasn't a constructive dismissal. So we need to always talk. I don't want you to call me after you quit. Call me before so we can do this right. The other thing is, in some cases, we may give the company the chance to fix the issue. Say, employer, I don't agree with this, so please go back to the way things were. And if they don't, then it may be a constructive dismissal. So don't quit and then call me. If you did already quit, absolutely call me. We'll make it work. In an ideal scenario, if you're facing a change to the terms of employment, right away. Don't accept it. Don't continue working and ignore it. Just call me right away and we'll put a plan into place.
We've often said this on the show as well. Even if it's something you really love your workplace, you love your gig, it's like, can you try something out maybe and say, if this works for me, okay, I'll go for it. But in writing, I'm not signing pen to paper completely on this one yet.
Yeah, so some changes, you know, you may say, well, I know I don't like this, but maybe it's not going to be that bad. You know, I spoke last week with someone where her commission compensation was changed, her commission structure, but the company says, you know what, you may be able to earn commissions on other things, so it's going to all even out in the wash. So what we did there is we said, okay, well, I'm going to try this till the end of the year and then see where we're at. And then if I realize that by changing my commission, I actually took a pay cut, we're going to then pursue a constructive dismissal potentially. So you have an opportunity to change or to try a change. Let your employer, you're trying it, you're not accepting it, you're just going to try it for a period of time, and then you're still leaving the door open to potentially pursue a constructive dismissal. Lots
more questions to go, but we'll do that on the other side of the break. So I'll give you that contact information again as we get into that break. 1-855-821-5900, help@employmentlawyer.ca, and that website always pocketemploymentlawyer.ca as well. More of the Employment Law Show's coming up. Stay with us. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca.
If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back. Thanks for hanging in. Employment Law Show here. John Scholes and Lior Samfiru. Reach out anytime to have that conversation on your own time with Lior, a member of his very capable team. 1-855-821-5900. Help at employmentlawyer.ca and the option of pocketemploymentlawyer.ca. That website's a beauty. You'll learn a ton. Severance calculators on there as well. You'll have free access to that. And of course, a contact button on the top right. And including, in addition to that, rather, YouTube, Facebook, Lior is all over social media. He does a lot of chats on there as well. You can join into that. Simply go to stlawyers.ca, stlawyers.ca. For this week, Lior, a question as follows. Says, I've been given a month's working notice by my employer. I've been in a senior management position with this company for the past 6 years, and I'm nearing my 60s. Is a month's notice considered enough time to find a similar job?
It's not even close. And certainly, you know, the more senior you are and the older, the law assumes, right or wrong, and I think correctly, that you're going to take longer to find another job. So after all this time here, 6 years, that's not even close. In many cases, okay, you're going to be owed as much as a month per year, sometimes even much more than a month per year. So to give someone a month's notice after 6 years of employment, it's silly. That's going to be a wrongful dismissal every day of the year. The question becomes, well, what does that notice mean as relates to severance? Are they the same? Well, for our purposes, they really are the same. So that month's notice that the person got does count towards their severance. So whatever severance they're owed, we reduce it by the month's notice that they were provided. If they had been provided sufficient notice, then they wouldn't have been owed any severance at all, but not even close. So now let's find out the real question, the big question: how much notice/severance should this person have received? You know what we're going to do. We're going to go back to our severance calculator tool. You'll find it, of course, pocketemploymentlawyer.ca. And let's see what that gets us. So this is an individual is in a senior role, been there for 6 years, almost 60 years old, 59, was offered 1 month's notice/severance. Well, you see there, he's owed as much as 9 months' pay. And I'm going to say something else. I think it's probably even more than that. I think it could be as much as 12 months, even in the right circumstances, depending on the role. But a heck of a lot more than 1 month. That's why we use the severance calculator. That's why you have to use it at home as well if you're let go. Doesn't matter if you're there for a month, for a year, for 20 years. Check it out. It's free and anonymous.
Okay, second live stream and Facebook, YouTube question. Lior, again, anytime you want to join in, your question may appear on this show, right, at stlawyers.ca. Says, I was asked by my employer if I'd be interested in a promotion. I had a verbal conversation and I was promised a raise if I agreed to run this new project. It's been 3 months now and I still don't have a new contract. My pay remains the same. Is my employer legally bound to honor that promise?
So a contract is a contract, and it has to be enforced even if it's verbal. So a verbal contract is still a contract as long as you can show what the terms were. The problems with a verbal contract often is it becomes a he said, she said, or one party may deny that it even happened. So in this case, if the deal was, I'm going to take on this project, and as an exchange, you're going to give me more money for it, well, that's an absolute contract. But there has to be some proof of the deal. Always a good idea to have something in writing. You don't have to have a formal contract drafted up. Frankly, an email that says, yeah, we agree that I'll pay you more if you take on this project, that's good enough because it's evidence of the contract. In this situation, what I would do is I would send a company an email saying, remember when we agreed back in whatever month it was that you're going to pay me more? When can I expect that? All you want is some confirmation from the company that, in fact, that's true. Yeah, we did talk about that and we agreed, but we'll see what happens. Well, once the company acknowledges that there was a deal, you can enforce that deal. But always a good idea, if you agree to something with the company on a promotion, on a raise, on changes to your job, things that you've asked for, get something in writing. One brief email does all or makes all the difference, and it makes it legally enforceable.
All right, Lior, time's ticking away. It's time for the Employment Law Show. Rapid fire questions right here. Okay, let's get it happening. Question number one, pal. Does an employee have to inform a prospective employer if they are pregnant?
No, absolutely not. There's no obligation whatsoever to inform that you're pregnant. There's no obligation to inform your employer at the end of your leave when you're coming back necessarily, unless you've decided that. So that's up to the parent. If you've decided, I'm going to tell, you can tell. And, you know, in some situations, I've seen parents or prospective mothers not tell their employers until later in the pregnancy. It's your right. Your employer may want to know earlier, but they cannot get upset at you for telling them later in your pregnancy, for telling them later when you're going to be off. That's within your rights. Nothing can happen to you.
Rapid fire question number two. Can an employer hire a temporary replacement for an employee that is on leave?
Absolutely. An employer is still allowed to run its company to get the job done while you're, of course, on a leave. And that may mean either giving someone else the job that you had while you're on a leave, hiring someone else, reorganizing a bit to get the work done. So that's absolutely fine. So never stress out about what's happened to your job while you're away. Let the employer run its business. The key is your job being there for you when you're ready to come back.
The question we always ask, you know, that you get that replacement employer or employee and they're an absolute rock star. Can that employer decide to keep that replacement employee?
No. Remember, we're talking about parental leave here. In the parental leave situation, no, an employer cannot decide to keep the replacement. Now, they can keep the replacement as long as they still bring you back to the same job. Maybe two people can do the job. As long as you're doing the same job with the same pay, no issue if the company wants to have two people. So they don't have to necessarily fire the replacement. But if they can't use that fact that there's a replacement to say you no longer have a job, we hired someone else, that would be illegal. Can't do that at all. You should always be brought back to the same job, same pay, no questions asked.
Employment Law Show rapid fire question number four, Lior, is this. I'll lob an easy one over the plate. Can an employee be let go while on maternity leave?
Well, it's easy and it's obvious. Of course not. And despite that, I still see that often, way too often. You cannot be let go because you're on a leave, because you're about to take a leave, because you've extended your leave. Cannot. You have the right to do all of those things. You have the protection of the law on your side. Letting you go could be a breach of several statutes. Significant entitlements are going to be paid. The law takes that very seriously.
Question number five. Now we are getting into the hot water here with this one. Is terminating an employee due to pregnancy or maternity leave a human rights violation?
It sure is, absolutely. We have a human rights code that protects employees from being let go, from being mistreated, from anything happening to them. If you're pregnant, if you're about to be a parent, can't do that, can't happen. And human rights violations are a serious matter. Our human rights law, arguably some of the most important protections that employees have in this country. So to be let go in a pregnancy or parental situation, a human rights violation cannot happen.
This is a question we don't often ask, and we tacked it on the back of the rapid fire here for question number six. How about the fellas? Do the male employees also have the parental leave, same rights as the mums?
Now, in terms of job protection, in terms of not being able to be fired, in terms of getting your job back at the end of the leave, it's exactly the same rights. Father, mother, parental leave, job protection, all those apply to you as well. By the way, it also applies to those that adopt a child. All these rights are there for you, and you have to ensure that no one else ever tells you otherwise.
That is the rapid fire for this edition of the show. I love putting Lior in the hot seat, but it never works. It always cools off really quickly. You can always reach out with your own questions anytime you would like. Make the phone call to Lior and his team, 1-855-821-5900. That email address we use every week is help@employmentlawyer.ca. And that website, it was built just to make you smarter. It's free, it's anonymous, access to the severance calculator as well, and contact. It's a beauty. That's called pocketemploymentlawyer.ca. Use that and get back to us next week how much you enjoyed it, right? And we'll see you next week on the next edition of the Employment Law Show. Thanks for joining us.